Hello, my name is Stephen Lee, and I'd like to celebrate Asian Pacific American Heritage Month with you by talking about an important case in Asian American legal history, an 1850s murder case that had huge implications for civil rights in the 1850s and 1860s in California. This is also a case about two judges who had very different views about the purpose of the law and who the law was supposed to protect. The case begins with a murder in 1853 in Gold Rush Country in the Sierra Nevada mountains in California. Three prospectors came upon a camp of Chinese miners and attacked the camp, attacking one man and ultimately killing another man. Now, what's important about this case is that the government actually did what you would hope the government would do in a case like this. The prosecution arrested the three men, held them in custody, and took them to trial, even at great expense. The prosecution here was led by a man named William Stewart, who later became famous as a senator from Nevada, who was actually involved in helping draft the 15th Amendment and who briefly hired Mark Twain as his personal secretary. William Stewart led the prosecution team and went to great expense to bring the case, even going to San Francisco to find a Presbyterian minister and recruiting that minister to serve as a translator for the trial. The prosecution called multiple Chinese witnesses to the crime and also called at least one white person to testify at the trial to corroborate what the Chinese witnesses had said. And as a result, the jury came back and convicted George Hall for the murder. This brings us to the first of our two judges, Judge William Barber. George Hall asked Judge Barber for mercy, asking for a new trial or for a light sentence. Judge Barber rejected both of these requests. And he gave words stirring, even now, to George Hall. You, most unfortunately, have participated in a delusion which has prevailed to an alarming extent in California. Many persons here have supposed that it is less heinous to kill a Negro, an Indian, or a Chinaman than a white person. This is a gross error. The law of our country throws the aegis of its protection upon all within its jurisdiction. It knows no race, color, or distinction. Now we come to the second judge in our story, Chief Justice Hugh Murray of the California Supreme Court. George Hall appealed his conviction and his sentence to the California Supreme Court, and the prosecutor, William Stewart, did not think much about the appeal initially because there had been no exceptions or objections made during the trial, and thus there were little grounds, if any, for an appeal. Unfortunately, Chief Justice Murray wanted to find a way to free George Hall, and did so by taking a law that already had massive civil rights implications and expanded that law to effectively undo the conviction. California law at the time prohibited black people, mixed race people, or Indians from testifying against white men at trial. Justice Murray took that statute and extended it to prevent any non-white person from testifying against a white man at trial. Now, Justice Murray was able to extend California law in this way by adopting racial views that were not even consistent with what people generally believed in the 18th or 19th centuries. There were scientists who had classified people by race, but none of those classification systems would equate a Chinese person as being an Indian or a black person. But that's the view that Justice Murray came to because he wanted to find some way to protect white people from the testimony of Chinese people or any non-white person. Justice Murray's decision set George Hall free, but it also had massive implications for all Chinese people and all non-white people in California at the time. As a result of the decision, all non-white people could not testify against white people who committed crimes against them, and they all faced greater risks of being victims of crimes as a result. Fortunately, California changed its law in the 1870s, thus allowing Chinese people and all non-white people to testify against the people who committed crimes against them, white or otherwise. I first learned about People versus Hall back in law school many, many years ago. The opinion by Chief Justice Murray was offensive and it was wrong. But what struck me was that Chief Justice Murray would not have been in a position to even write his opinion if other people had not done the right thing first. A judge cannot overturn a conviction unless people fought for that conviction in the first place. I wanted to find out more about those people myself, and I ended up doing research in the New York Public Library, the California State Archives, and even in a library in Nevada County itself. That's how I learned about William Stewart and how I learned about Judge Barber. I still remember how thrilled I was to discover and read Judge Barber's words for the first time. Words that were spoken before the Civil War, before the 14th Amendment, before the Civil Rights Movement. Words from a time and a place where you would not expect such principles to be fought for. I hope you've enjoyed this look at People versus Hall, and I hope you join me in celebrating Asian Pacific American Heritage Month. Thanks for watching.